Hello बच्चों, let's see passage 2. Passage 2 talks about information contained in a document if replicated can be subject of theft and can result in wrongful loss even though the original document was only temporarily removed from its lawful custody for the purpose of extracting the information contained therein. तो बेसिकली ये बोल रहा है कि अगर आप कोई भी ऐसा डॉक्यूमेंट निकालते हो जो ओरिजिनल है और उसको रेप्लिकेट करते हो, अब रेप्लिकेट करते हो अगर तो वो थेफ्ट माना जाएगा, और जिसका रिजल्ट रॉन्गफुल लॉस है सामने वाले को, तो हम इसको एक्सट्रैक्शन ऑफ इंफॉर्मेशन बोलेंगे. द फॉलोइंग रिक्वायरमेंट्स नीड टू बी एस्टैब्लिश्ड इन ऑर्डर टू मेक आउट द केस ऑफ थेफ्ट अंडर सेक्शन 378 ऑफ आईपीसी. So section 378 talk about the theft of the for what are the essential requirements. First is to take away movable property. अब obviously movable होगी तभी आप उसको उसकी lawful custody से हटा पाओगे. Second is कि आपको wrongful gain होना चाहिए उस प्रॉपर्टी की वजह से, और सामने वाले को wrongful loss होना चाहिए, आपका एक dishonest intention होना चाहिए. फिर बोल रहा है whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent. अब अगर यहाँ पे पर्सन का कंसेंट की बात हो रही है, अगर आप ऑब्वियसली अगर आपने सामने वाले के से पूछ के लिया है कि भाई मेरे को, जैसे आप अगर किसी के नोट्स ले रहे हो कि मैं फोटोकॉपी करवा लूँ क्या, मेरे को भी पढ़ना है, तो वो आप उसका कंसेंट लेके उसके ओरिजिनल डॉक्यूमेंट के रेप्लिकेट कर रहे हो, तो ये रॉन्गफुल गेन या लॉस करने के लिए नहीं है. moves that property in order to such taking is said to commit the theft. The offense of theft is complete as soon as the property is removed in order to such a taking. If it is not necessary that the person from whose possession the property is taken is the true owner or the real title of the property. It is also called modified intention, which can be represented in the form of mens rea. तो अब ऑब्वियसली अब जैसे आपका फ्रेंड लेके गया आपसे पूछ के नोट्स, आपकी कॉपी लेके गया, अब उसके पोजेशन से भी अगर कोई चुरा ले रहा है उस कॉपी को जस्ट टू रेप्लिकेट द इंफॉर्मेशन, तो भी वो थेफ्ट में माना जाएगा. जरूरी नहीं है कि वो जो जिस भी इंसान से लिया गया है वो ट्रू ओनर हो या उसके पास रियल टाइटल ऑफ द प्रॉपर्टी हो. जहां पे भी मालिफाइड इंटेंशन या मेंस rea प्रेजेंट होगा वहां पे थेफ्ट होगा. This is the core element of the theft. The petitioner has to prove that something was taken away by someone with a dishonest intention. तो एक तो taking away है और दूसरा है dishonest intention. The subject of the theft is movable property. Immovable property cannot be stolen. Movable property is a type of property which is able to move easily and is not stationary or which is not immovable. तो basically movable property ही थेफ्ट के केसेस में कंसिडर किया जाता है, क्योंकि इमूवेबल प्रॉपर्टी को हम स्टील नहीं कर सकते, क्योंकि ऑब्वियसली वो इजीली मूव नहीं हो सकती और वो स्टेशनरी होती है, जो कि केस नहीं है मूवेबल प्रॉपर्टी के लिए. ऑन द अदर हैंड द काइंड ऑफ प्रॉपर्टी विच कैन नॉट बी मूव्ड एंड इज अटैच्ड टू द अर्थ इज कंसिडर्ड एज इमूवेबल प्रॉपर्टी एंड इट इज नॉट द सब्जेक्ट ऑफ थेफ्ट. इट बिकम्स द सब्जेक्ट ऑफ थेफ्ट व्हेन इट इज टेकन आउट ऑफ फ्रॉम द सरफेस ऑफ द अर्थ. अब जैसे कि आप मान लीजिए कि एक पेड़ है जो आपके गार्डन में उगा हुआ है, तो हम इसको इमूवेबल प्रॉपर्टी मानेंगे, बट तो ये सब्जेक्ट ऑफ थेफ्ट नहीं होगा. बट जैसे इस पेड़ को कट कर दिया गया, इन ऑर्डर टू टेक दिस पेड़ अवे फ्रॉम योर प्रॉपर्टी, दिस विल बी कंसिडर्ड एज मूवेबल प्रॉपर्टी एंड विल बी सब्जेक्ट टू थ्रेट, क्योंकि ये जो अटैच टू अर्थ था आपने उसको डिटैच कर दिया अर्थ से, तो अब ये मूवेबल प्रॉपर्टी बन गया. द मूवेबल प्रॉपर्टी मस्ट बी इन पोजेशन ऑफ अनदर इंडिविजुअल फ्रॉम वेयर इट इज टेकन अवे. देयर इज नो थेफ्ट ऑफ वाइल्ड एनिमल्स, बर्ड और फिशेस while at large, but there is a theft of animals which are owned by someone else. Let's see the questions. Sixth says that day Amitabh had to come to study at Kabir's house and forgot to bring his pencil box and thus borrowed a pen from him. However, while leaving, he forgot to return the pen and instead kept it in his pocket. Is he guilty of theft? तो अब इसमें बेसिकली क्वेश्चन में ये बोल रहा है कि ही फॉरगॉट, मतलब यहाँ पे मेंस रिया या इंटेंशन नहीं था उसका कि वो पेन को कबीर के पोजेशन से बाहर लेके जाए. तो लेट्स सी द ऑप्शंस. ए सेज नो, अमिताभ डिड नॉट पोजेस एनी डिसऑनेस्ट इंटेंशन to take the pen away and thus would not be guilty of theft. As discussed, A will be right option, क्योंकि कोई dishonest intention नहीं था, तो इसलिए theft नहीं होगा. theft होने के लिए dishonest intent होना चाहिए. B says yes, Amitabh was the kleptomaniac and thus he acts his acts would fulfill all the ingredients required to make a person liable for the theft. Before deciding whether this option is correct or not, let's understand what is kleptomanic. Kleptomanic मतलब एक mental disorder होता है जिसमें आप अपनी urge to steal को control नहीं कर पाते and you eventually steal things from people. But यहाँ पे ऐसा कुछ भी नहीं था और उसने कोई ingredients, उसने जो main ingredient है कि intent होना चाहिए वही fulfill नहीं किया था, तो this is a wrong option. C says no, since the law does not take into account trivial matters, the allegation of theft is likely to be dismissed by the court of law. This is again a wrong question. Because even though this is a trivial matter, it might be considered as theft, but here theft hasn't happened because the intent was not present. D says yes, there is a wrongful loss to Kabir which is not sufficient to make Amitabh liable for the theft. It is which is sufficient to make Amitabh liable for the theft. This is again a wrong option. It is not sufficient as the essentials are not fulfilled. Let's see the question number 7. It says when Amitabh went back to his home, he found an expensive ring lying on the floor. He picked up the ring immediately and without inquiring about the owner of the ring, kept it in his pocket. Later he went home. Is he guilty of theft? A says yes, he had the dishonest intention to dispose someone of the valuable ring, causing wrongful loss to such person, and thus would be liable for the. A is a wrong option because when we talk about the wrongful loss, it was not present because here the property was not wrongfully taken by the Amitabh, but the property was found on the road and hence he did not cause wrongful loss. So this is a wrong option. B says no, the property was not in the possession of anyone, therefore there is no theft committed by Amitabh. This is a right option because even though the property might be of someone, but when Amitabh took that property, it was not in possession of anyone, causing any wrongful loss, hence he is not liable. C says yes, Amitabh had the moral and legal obligation to inquire about the rightful owner of the ring instead of keeping the ring himself and is thus liable for the theft. This is again a wrong option because there might be an obligation of moral reasoning to find the rightful owner, but Amitabh did not have any legal obligation to do so, and hence this is a wrong option. D says no, Amitabh was a kleptomaniac, and by the virtue of the fact that this condition urged within his control, he did not possess dishonest intent, would not be liable for the theft. This is again a wrong option because he wasn't kleptomaniac. Something like this is not mentioned in the passage and we cannot go on assuming things. Let's see question number 8. It says the next day the news broke of the missing ring which belonged to the minister's wife who came there for an official visit, but their ring was stolen from the hotel which somehow might have landed on the road. After seeing the news, Amitabh thought that it is best to keep shut and did not return the ring. Is he liable for theft? A says no, the property was not in the possession of anyone at the time it was picked. Therefore, there is no theft committed by Amitabh. A is the right option because when Amitabh took the possession of the property, no one else was in the possession of that property and hence it will not amount to theft because in theft you have to take the possession of the property by which is already in possession of someone. B says yes, he had the dishonest intent to dispose someone of the valuable ring, causing wrongful loss to such person and thus would be liable for theft. This is again a wrong option because he did not have any dishonest intention and it was did not cause any wrongful loss क्योंकि वहां पे जब ring उसको मिली तब वो already किसी के possession में थी ही नहीं. C says no, the ring was originally stolen by someone else and there should Amitabh cannot be made liable for the theft committed by someone else. This is again a wrong option because even though it was originally stolen by another person, here what the question is asking when the Amitabh picked the ring, whether he'll be liable of it. D says yes, Amitabh was kleptomaniac and making him liable for this act as a way to improve him and get rid of the problem. This is again a wrong option. It's just mentioning the term kleptomaniac which has never been discussed in the passage. 9 question says there was a graveyard situated near the house of Kabir. One day while he was returning from home, he found a shining bracelet over body about to be buried and he went ahead and took the bracelet with him. Is he guilty of theft? A says no, there was no dishonest intention and it was to take from a dead body and would does not qualify as theft. This is a wrong option because saying that there was no dishonest intention is not right because Kabir went with his own consciousness to take the shining bracelet out of the possession of the body in order to have some wrongful gain. So this is a wrong option. B says yes, because even dead bodies have right under the law and cannot be disposed of the valuables which they are buried. This is again a wrong option, because this option is merely assumptive in nature and do not really analyze the question that has been asked. So this is a wrong option. C says no, the property was not in possession of anyone, therefore there is no theft committed by Kabir. C is the right option, because the bracelet was taken out of the possession of a dead body and hence not causing any wrongful loss to any person, and hence Kabir will not be liable for theft. So this is the right option. D says yes, there is a dishonest intention coupled with wrongful gain to Kabir and thus he would be liable for theft. This is again a wrong option, because even though there might be dishonest intention, it was not coupled with a wrongful loss to any person, and hence Kabir will not be liable due to the absence of wrongful loss. Let's see the last question, that is, Amitabh saw an ivy tree in the garden of his neighbor. Being fascinated by the beauty of the tree, he chopped off few of the branches of the tree and carried it home. Is he guilty of the offense of theft? A says no, the tree is an immovable property. Thereafter, theft is restricted to movable property only, and therefore there is no theft committed by Amitabh. This is a wrong option, because as being pointed out in the passage, once the immovable property is detached from the earth, it becomes movable property and hence a subject matter for theft. So this is a wrong option. B says yes, as soon as the branches were chopped off, those turned into movable property and thus theft would occur. This is a right option as discussed earlier. C says no, there was no dishonest intention, as the reason for taking the branches of the tree was pure fascination and not ill intention, and would therefore not qualify as theft. This is again a wrong option. There might be no dishonest intention, but the intent of taking the property out of the possession of the person was there, and that will make the person liable. D says yes, since the ivory tree is a valuable tree, taking away any part of it is an offense under state laws and Amitabh would be punished under the same. The answer here is right, but the reasoning here is not correct. So this is again a wrong option. I hope the passage was understandable. All the very best.